Hello students, a very good morning to all of you. This is Dr. Vishwanath Singh, Associate Professor, Govt Law College, Sriganganagar. I am going to discuss before you the concept of contract. What is contract? What are its essential elements and how the contract is formed? As you know, Section 2H of the Indian Contract Act 1872 defines that an agreement enforceable by law is a contract. But the question arises that how the contract is formed. The journey of contract begins from proposal. Section 2A in this regard provides that when one person signifies his willingness to do or to abstain from doing anything with a view to obtaining the assent of another to such act or abstinence, it is called proposal. Suppose A wants to sell his cycle to B for ₹100. Here A makes a proposal. If the proposal is accepted by B, then it becomes promise. In this regard, Section 2B says that the person to whom the proposal is made, if he signifies his assent thereto, the proposal is said to be accepted. When a proposal is accepted, it becomes a promise. Section 2C says that the person who makes the proposal is called promiser and the person who accepts the proposal is called promisee. Section 2E says that where a promise and set of promises forming the consideration of each other, that is called agreement. Here, promise or set of promises means that there must be consideration for both parties. If there is no consideration, then a valid contract is not possible. What is consideration? Consideration means when at the desire of the promiser, the promisee or any other person has done or abstained from doing or does or abstains from doing or promises to do or to abstain from doing such act or abstinence or promise is called consideration for the promise. Here consideration means value. Value means you can say that if A makes a proposal to B to sell his cycle for ₹100, here the consideration for A shall be ₹100 and for B the consideration shall be cycle. In short, it can be said that proposal plus acceptance is equal to promise, and if there is a consideration in the promise for both parties, it becomes an agreement. But what agreements can be said to be contract? In this regard, Section 10 says that all agreements are contract if they are made with the free consent of the parties competent to contract for a lawful consideration with a lawful object and are not expressly hereby declared to be void. If we analyze Section 10, we find 5 elements. Number 1, competency of parties. Competency of parties means that who can enter into a valid contract. Section 11 says in this regard that every person is competent to contract who is of the age of majority according to the law to which he is subject and is of sound mind and is not disqualified by any law for the time being in force to which he is subject. The age of majority has not been defined under Indian Contract Act, but it has been defined under Section 3 of the Indian Majority Act 1875, which says that a person becomes major when he completes the age of 18. After the completion of 18 years, a person becomes major and is entitled to enter into a valid contract if all other things are satisfied in this regard. The soundness of mind of a person has been provided under Section 12, which says a person is said to be of sound mind for the purpose of making a contract if at the time when it makes it, he is capable of understanding and is of forming a rational judgment as to its effects upon his interests. A person who is usually of unsound mind but occasionally of sound mind, he may make a contract when he is of sound mind. But on the other hand, if a person who is usually of sound mind but occasionally of unsound mind, he may not make a contract when he is of unsound mind. The other point I want to discuss before you is that there is a line under Section 11 which says, and is not disqualified by any law to which he is subject. It means that a person who is going to enter into a contract should not be disqualified by any provisions of any law to which he is subject. I would like to quote an example from Transfer of Property Act 1882. Section 136 provides that no judge or legal practitioner or any officer connected with the Court of Justice, he cannot take any share or receive any part from the actionable claim. It means for making an agreement for actionable claim, a judge, legal practitioner, or any officer of the Court of Justice has been prohibited to making an agreement regarding actionable claim. So, for the purpose of making an agreement for actionable claim, these persons have been disqualified. The second element of Section 10 is free consent. Free consent has been given under Section 14, which says that a consent is said to be free when it is not caused by coercion under Section 15, undue influence under Section 16, fraud under Section 17, misrepresentation under Section 18, and mistake under Section 20, 21, and 22. The third element is regarding lawful consideration. What is lawful consideration and what considerations are not lawful has been given under Section 23. It says that the consideration of an agreement is lawful unless it is forbidden by law or is of such a nature that if permitted, it would defeat the provision of law, or is fraudulent, or it implies or involves any injury to the person or property, or the court regards is as a immoral or opposed to the public policy. The fourth element is regarding lawful object. Remember here that the provisions of section 23 and 24 both are applicable to the lawful objects also. One thing I would like to remind that section 24 provides that if the consideration or objects are unlawful partly, then the agreement shall be deemed to be void. The fifth element of section 10 is regarding, there is a line in section 10 which says that and is not expressly hereby declared to be void. It means that there are several provisions under the Indian Contract Act which expressly declared the agreements void. For example, see section 23, 24, which expressly declared the void agreements on the ground that it was caused for unlawful consideration or unlawful objects. In the same way, section 25, which says that an agreement made without consideration is void. Section 26 says that agreement in restraint of marriage is void. Section 27, agreement made in restraint of trade is void. Section 28, agreement made in restraint of legal proceedings are void. Section 29, if there is uncertainty or uncertain agreement, that is also void. Section 30, an agreement by way of wager is void. Section 56 also provides then an agreement to do impossible act is also void. In the last, there is one more important element for a valid contract is an intention to create legal relationship. Remember it that this element is not under the statutory provision, but it has come from the English decisions. So you have to refer the case of Balfour versus Balfour, Jones versus Padwetton, and Merritt versus Merritt. Thank you.